Yeah.
What is this? This is Bill.
It's the state.
Hi, how you doing?
All rise. Everyone stand, please. Oyez, oyez, oyez. The Honorable Superior Court in the Judicial District of Stanford and Norwalk in Stanford for the transaction of criminal business and now open the session in this place. All persons having cause or action pending or summons or bound to appear in shall take due notice and show their attendance according to the law. Court is now open the session beyond the Judge White presiding. Good morning, Your Honor.
Good morning. You can be seated. Good morning.
Your Honor.
Okay, we're here on the case of State v. Michael Skakel. Defendants here, counsel are here, bail commissioners here. Counsel, identify yourselves, please.
For the state of Connecticut, Your Honor, John Smriga, S-M-R-I-G-A.
Yes, good morning, Your Honor. Hubert Santos on behalf of the defendant. Along with me is Attorney Jessica Santos.
All right, thank you. The defense has filed a motion to set a bond in this case. There's no opposition by the state. Therefore, I'm going to grant the motion to set a bond. And I'm ready to hear a bond argument by the state and the defense, and I'm ready to hear from the bail commissioner.
Good morning, Your Honor. Michelle Muniz with the Bail Commissioner's Office. Your Honor, the defendant is 53 years old, has been a resident for the last 43 years in the state of Connecticut, has one dependent, has completed 16 years of education. He does self-report a mental health issue, and he has no Connecticut convictions under the name and date of birth given to our office. My recommendation for bond is a $1 million bond with the condition he's placed on a GPS. He calls the bail commissioner once a week, and he has no contact with the victim's family, as well as he is not to leave the state of Connecticut without permission of the court.
State.
Your Honor, as far as what is the state's position, do you want to hear an argument at this point?
Yes.
Your Honor, I think the first thing I'd like to do is comment on the unusual procedural history, although we've heard from the bail commissioner, which is usual in these instances. Obviously, I've never seen this particular sort of a procedure before because normally when the court is in a position of having to consider bond, it is because a person has been recently arrested and is brought before the court. Generally speaking, that occurs after someone has either been arrested on a warrant, so before the court, someone where probable cause has been determined by either the court itself or another court, or the court is presented with some arrest materials because a person has been arrested without a warrant. In this case, the procedural background of this is quite a bit and substantially different. Obviously, the crime occurred itself in 1975. But legally and prior to today, the posture of the case is quite a bit different. Number one, this case began because it was the result of a grand jury investigation. During the course of that grand jury investigation, Judge Thim, after hearing many witnesses, decided that there was probable cause for the arrest of the defendant. Thereafter, there was a warrant, probable cause was found, and when the defendant was arrested, he was initially brought to the juvenile court where there had to be a hearing. And at that time, there was probable cause found there as well. So we've had multiple findings of probable cause and ultimately a conviction that was the result of a jury finding that the defendant was guilty of the crime of murder. That was directly appealed to the state Supreme Court. And that appeal was denied. There was a motion for certiorari to the U.S. Supreme Court. At that time, That was denied, and it was the U.S. Supreme Court declined to hear that. And thereafter, Your Honor, there was a petition for new trial. Petition for new trial was heard here in Stanford, and Judge Carrison heard evidence in that case. The petition was denied. There was an appeal of the denial of the petition. The state Supreme Court also denied the appeal in that case. So we come forward. There was also a federal habeas claim that was filed with the federal court, and in that instance, I believe the federal court said that the remedies by the defendant had to be exhausted in the state court. There's a stay of the federal habeas. What brings us here is in 2010, in September 27th, the defendant filed a habeas corpus petition claiming that his counsel was ineffective. There was a trial, and after which the trial referee, Judge Bishop, who heard the case for the first time, actually vacated the conviction and remanded the matter for a new trial, and that's why we're here. The state took the position that it would not seek review of a lifting of the stay, which puts us here today. So we're in a very strange posture where the trial is pending and also the state's appeal is also pending. There was an agreement, and I think just to put on the record, there's been an agreement that there would be a stay of the trial proceedings, and also there would be a waiver of the defendant's right to a speedy trial so that the appeal could be heard, and we're not trying to compete with the appeal by possibly having trial proceedings in the meantime. So that's where we are today. Now, the court mentioned that the state does not oppose bond. The reason that the state is not opposing bond, because we have looked at the issue and do not believe that there's any legitimate argument. The defendant here, having had his conviction vacated, is entitled to bond. There's just no legal theory that the state could offer, which we would expect the court to accept, that would prevent it from setting bond. So we're in a situation where we're back to listening to the bail commissioner, and other than the fact that we have this long procedural history and a long testing of the conviction in other forms, we are here for the court to set bond. So I think the question really boils down to, at this point, is what the appropriate bond is. And I note that the defendant has requested a $500,000 bond. And I think that although I will not be giving a number specifically to the court that I believe is appropriate, I can say that $500,000 is not appropriate. And I would like to just give the court my thoughts about why I'm saying that. We agree with the defense in its brief that cites the Connecticut statute for what the appropriate factors would be to consider in determining whether what the bond should be and whether a bond should be set at all, or what the type of bond that would be necessary. And these are factors to consider. Some of them are hit in the defendant's brief. But the things that I would like to ask the court to consider are, number one, the nature of the offense. It is a murder, so the seriousness of the offense. It's a very serious crime, and it was a particularly brutal crime. The victim, I'm sure the court is aware, was a 15-year-old child at the time that she was brutally murdered, we claim, by the defendant. Now, the other thing that the court must consider in terms of the number is the personal resources of the defendant. And in that sense, this is in 5464A, F, the personal resources of the individual, the character and mental condition. I would also note, although the state does not have any specific results or analysis of the defendant's psychiatric condition at the present time, I would note that in the brief that has been filed here and the court has in its possession, the defense has mentioned on several occasions that there has been, over the years, prior to his incarceration, a concern about the mental health of the defendant and continued treatment and rehabilitation facilities, as well as medication for mental issues. And I think that is something that should seriously be considered by the court. Now, the one thing that seems to be primary in the claim of the defendant is the weight of the state's case. This is something that we contest. As I alluded to before, the weight of the state's case has been tested over and over and over again by various forums, and only until recently it has been sustained every time. Cited by the defense, for instance, is the dissenting opinion in the direct appeal from the jury trial, the original jury trial, where the dissenting opinion was rejected by the majority. So this is what the defense offers to demonstrate that the weight of the state's case is not great. And of course, the second major thing that is mentioned is the decision of Judge Bishop, where Judge Bishop found that Mr. Sherman, who practices in this court regularly, and I think I first saw Mr. Sherman practicing in this court in 1981 when I worked here many years ago. He'd already been here before me. And Judge Bishop found that Mr. Sherman was effective in virtually everything that he did. And this is something that we are going to be challenging on appeal. Now, ironically, I would point out that Mr. Sherman was the lawyer selected by the defendant, presumably because he was very experienced and had a reputation for proficiency, and also had a reputation for being proficient in handling of matters that are of interest to the press. So this is, out of all the universe of defense lawyers, the defendant selected Mr. Sherman, and now he claims that, and Judge Bishop agrees that Mr. Sherman was virtually ineffective in virtually everything that he did. We believe that the state has a strong argument that the court applied a wrong standard, an incorrect standard, and that we strongly believe that there is a likelihood that his decision will be reversed on appeal. Now, obviously, if that happens, and the defendant has a bond is set, and the defendant has made that bond at the point that any decision was reversed, the defendant would be subject to return to prison at that point without a trial. If the appellate court agrees with Judge Bishop, then we go forward with a trial. So he's still subject to possibly returning to prison at that point. So now the issue becomes, what's the amount? And I think that is something that the court does all the time. And it is sort of an art rather than a science. There are many things to consider, and I'm sure the court does that every day. I would just simply point out, Your Honor, and I have taken the opportunity, and I would like to approach the bench and hand the court a printout from the clerk's computer, basically a report of 259 cases which are currently pending in the state of Connecticut. May I do that, Your Honor?
Yes.
Thank you. Counsel has a copy.
All right.
It is, in the form of the report does not have the individual charges, but these are murder cases, and these are not 259 murder cases because, unfortunately, the way the report is generated, it also includes attempted murder cases. So, and also it does not, they're not simply murder cases. Many of them have additional charges as well. But now, I can, without knowing the background of each of these individuals, we do a lot of this in Bridgeport. I know they do them in Stanford here, where unfortunately there are many people who are charged with murder. And it is unusual, I think the background of the defendant is unusual in this regard. Most of these murders, I think it's fair to say, are murders that have occurred in an urban environment. and they are generally people accused who are younger than the defendant and do not have the background of the defendant in terms of his experience traveling the world, his financial resources, and that sort of thing. I think that just looking over it was remarkable looking over the biography that is provided. The numbers that are represented in this report are not people who have traveled the world skiing or have met Mother Teresa. I can assure the court that. But in any event, as I say, I think $500,000 in this situation is not adequate. It would not be. It would be out of pace with the defendants who have significantly higher bonds and do not have the resources to make them. And I think even if you look at the list of cases, 1 million is also on the low side. And I would suggest something closer to 2, Your Honor.
Thank you. Mr. Santos?
Yes, thank you, Your Honor. Your Honor, this, I'd like to give some background that I think is relevant to bond. And what had happened here is a one-man grand jury was convened and eventually hearing evidence recommended the arrest of the defendant. And as soon as the warrant was signed for the defendant, on that date he was residing in Florida. His lawyer called him in Florida and said that a warrant has been issued for his arrest. He immediately got on a plane and flew here to Connecticut to surrender to that warrant. Did not require extradition or any other process to get here, but voluntarily appeared. He appeared before Judge Comerford, and Judge Comerford heard the respective position of the parties and set a bond of $500,000, which the defendant posted. He then, of course, went through the whole procedure of the trial, the interlocutory appeals before the conviction, and the conviction itself, and each and every time the defendant was here, was present, was on time, available. And so you have a track record which you most likely do not have when a person is first presented on a charge such as murder. Here we have a track record of an individual who has appeared every time he was asked to appear. Once the appeal happened, under this 99 or 98 statute, no bail could be posted for the appeal because he was then convicted of murder, and then he's been in jail ever since for over 11 years. There is a reasonable likelihood that the sentence may not go beyond 12 years because of the law as existed at that time. In the 70s, there were murder cases that I handled all over the state of Connecticut, and if a defendant received the maximum sentence of 25 to life, then he was maxed out and released at 18. Now, the parole board in Michael's case continued the case for 5 years, and we think that there's good reason to believe that that was illegal because at a 20 to life sentence, he probably maxes out at 12. But that is nothing I can say authoritatively. Then you look at the case itself and the circus atmosphere that it's created down here in the Stamford, Norwalk area and throughout the state of Connecticut, where there was a circumstance at this trial that he never got a fair trial because of the enormous publicity and the influence of other people. Now, here's a case that Judge Bishop correctly notes in his memorandum of decision is not a strong case by the prosecution. Matter of fact, as we were following this case up in Hartford very carefully because of the nature of the case and our general specialization in criminal law, the general consensus was that he was going to be acquitted. Everybody thought that, including his major antagonist, Dominic Dunn, the author. He was shocked by the verdict. Other people were shocked by the verdict. And the general consensus is that the brilliant summation delivered by Mr. Benedict, then the state's attorney, really turned the tide in terms of the jury's eventual decision. No DNA evidence, Your Honor. No fingerprints. No trace evidence. No eyewitnesses. The key witness in this case came forward after watching a TV segment offering a reward. This Mr. Coleman, a heroin addict, comes forward and says to the prosecution, 22 years earlier, Michael Skakel admitted to me that he committed the murder. And then the patchwork of witnesses that showed up at the trial. If the prosecution found a homeless guy at the train station who said 22 years ago Michael Skakel told me he murdered Martha Moxley, he'd be on the stand in a New York minute. And this is the quality of the evidence that was presented against this man. But because of the atmosphere that was created by Dominic Dunn, Mark Furman, and all the others, that really was the death blow in terms of him getting a fair trial in this judicial district. Your Honor, I think we submitted to Your Honor the activities that our client was involved in once he matured and got involved with the Alcohol Anonymous program, and the tremendous good works that he did, his attempts to spread the word of AA to Russia, to other places, his good works, all of which were submitted to Judge Kavanowski at the sentencing in 2002, and we basically have incorporated that in our motion to give Your Honor some background of what the defendant was doing once he became mature. And I suspect that had a lot to do with Judge Kavanowski giving 20 to life instead of 25 to life. So what I'm saying to Your Honor is that he's got an excellent track record. He's one of the most recognizable faces in America. And so he's not going anywhere. He wants to see his son. One of the great tragedies, and a lot of tragedies in this case. One tragedy is the death of Martha Moxley. No one can even comprehend that type of loss in probably the safest neighborhood in the world. And so the other tragedy in our judgment is that an innocent man has been convicted. And that will wait for another day. When Michael went into jail, his son was 3 years old. He's now 14. He's had contact with him by phone, maybe saw him a couple of times. But in the final analysis, he's lost those years. It's one thing to lose years of freedom when you're innocent. It's another thing to lose the contact with your child during that period. Now, I know there's others that'll differ as to what the state of the evidence is, and I respect their point of view. But this is not a strong case against the defendant, which Judge Bishop duly noted in his 136-page opinion. So, if released on bail, Your Honor, we will provide, with the court's permission, to the bail commissioner where he intends to reside, and we'd rather do that privately because we're concerned about the media swarming all over him. Thank you, Your Honor.
All right, anything else from anyone?
Your Honor, not to retry the case, but I think that there were great pains taken to minimize the impact that media attention would have on this case initially. And it's not as if Judge Kavanowski was unaware that these things could be potentially a problem. The difficulty with a case that occurred in 1975 is that each time the facts of this case are revisited, they mutate. And it's very difficult to reconstruct them for reviewing courts and to go back there to the seat that the jury had when they heard it originally. And now it gets twisted, it gets misrepresented, and even looking at the transcripts and looking at reading the transcripts of other proceedings, it just gets mutated and more difficult to see. The whole idea that Jonathan Benedict was some kind of a Svengali, and it was the way he was able to put together the facts in this case, are all due respect to Mr. Benedict, I think that the idea that he wove a tale out of evidence that did not exist is ridiculous. The problem with this case is there isn't that one big piece. There isn't the DNA. There isn't the photograph. There isn't the reliable eyewitness that watched the crime occur. There's all very little pieces. And that unless someone takes the time to look at it very carefully, that overall picture does not come clear. It's like being handed a giant jigsaw puzzle and you don't have the box, so you don't know what it's supposed to look like. And that's what Mr. Benedict did. He told the jury what it's supposed to look like. And we're prepared to do that again if necessary, Your Honor. But I think that it should not be a matter where now we just say, this was a big fluke that occurred. No, it wasn't. And it was something that where the verdict had been in multiple forums reviewed and tested. So I would just ask the court not to look at this as some sort of a person who has been found guilty, not guilty. This is something where his lawyer has been found ineffective, and that's something we dispute. But he hasn't been found innocent by any forum.
All right. Thank you very much. I'm aware of the factual allegations and the procedural history of the case. I've read the defense brief, so I'm aware of Mr. Skakel's background. Under the totality of the circumstances, I'm going to set a bond of $1,200,000, and I'm going to put conditions on. One condition is that the defendant, Mr. Skakel, live here in the state of Connecticut. He may not leave the state without the approval of the court. He can notify the bail commissioner, and the court will hear why he wants to leave the state and where he's going and when he's going to return. He's going to have to wear a GPS tracking device. He is to have no contact with the victim's family unless it's necessary to do so. He can do that through his lawyer. And he's going to have to periodically report to the bail commissioner. He can do that by phone. Probably on a bi-weekly basis would be sufficient. Anybody else want to say anything? That's $1,200,000 cash or surety. Anything else?
No, Your Honor.
So the matter can go on the jury list for now. What's the date we used, Ryan?
11/11/19, Your Honor.
Okay, so 11/11/19 back on a jury list, and of course we're going to have to see what the appellate court of the Supreme Court does with Judge Bishop's decision.
Yes, Your Honor, we're prepared to post the bond now, so he won't be taken back to the prison.
All right, he's going to post the bond here.
Yeah.
All right, that's it. I'm sorry?
He has to come see me down at the bail office.
Yes, the defendant should see the bail commissioner in the bail commissioner's office.
I didn't hear that.
The defendant should see the bail commissioner in the bail commissioner's office before leaving the building.
Okay.
Okay?
Thank you.
Thank you.
All rise.